Received apologies from Deputy Mark Ward and Senator Michael McDougall. I just remind members to turn off mobile phones so that they don't interfere with the sound system or make it difficult for the parliamentary reporters to report the meeting. We have an item on our agenda today which is the pre-legislative scrutiny of the general scheme of the Irish Prison Service Bill. The purpose of the first part of the meeting, therefore, is to have an engagement with the stakeholders as part of the committee's scrutiny on the general scheme of the Irish Prison Service Bill, and the second part then will be to have an engagement with the stakeholders on the second item, which is the scrutiny of the general scheme of the Criminal Justice Legal Aid Bill. So just before I introduce the stakeholders who have come here, I'm just chairing in the place of the chair for the moment, but I want to declare an interest as I'm both a member of the Irish Penal Reform Trust and have been engaged on a professional basis on behalf of the Irish Prison Service. So just to let people, I don't have a pecuniary interest in either, but just to let people know that. But I want to welcome the following witnesses then from different groups on the Irish Prison Service Bill. First of all, Ms. Saoirse Brady, Executive Director of the Irish Penal Reform Trust. Ms. Helen Kehoe, Legal and Public Affairs Manager of the IPRT. Mr. Carl Dalton, General Secretary of the Prison Officers Association, and Mr. Gabriel Kehoe, also of the Prison Officers Association. And from the Department of Justice, we're joined by Paul O'Farrell, Principal Officer in Criminal Legislation, and Gerard Tehan, Administrative Officer. So you're all very welcome, and thanks for taking the time to join us. Before I invite you to deliver your opening statement, I want to advise you of the following in relation to parliamentary privilege. Witnesses and members are reminded of the long-standing parliamentary practice that you should not criticise or make charges against any person or entity by name or in such a way as to make him, her or it identifiable, or otherwise engage in speech that might be regarded as damaging to the good name of the person or entity. Therefore, if your statements are potentially defamatory in relation to an identifiable person or entity, you will be directed to discontinue your remarks. It's imperative that you comply with any such direction. So I'm going to invite each of the organisations in turn to make an opening statement to a maximum of 3 minutes. Once all the opening statements have been delivered, I'll then call on the members of the committee in the order they indicate to me to put their questions. The committee operates a rota system which provides each member with an initial 6 minutes to engage with our witnesses, and it's important to note that the 6 minutes is for both questions and answers, and therefore it's essential that members put their questions succinctly and witnesses be succinct in their responses. When all members have indicated they have had their initial engagement, and time permitting, a second round will commence where each member will have up to 3 minutes for both questions and answers. But please note that the duration of this meeting is limited and therefore the times must be strictly adhered to, so I ask everyone to be focused on their contributions. So I'll now call on each organisation to deliver your opening statements, and I'm going to start with the IPRT and Ms. Saoirse Brady. 3 minutes, please.
Okay. I'd like to thank the committee for the invitation to speak here today on this important piece of proposed legislation. Established in 1994, the IPRT is Ireland's principal independent NGO working for systemic penal reform and change. Our vision is a just, humane Ireland where prison is used as a last resort. We urge the committee to give this general scheme its full attention to ensure that the final legislation is fit for purpose and that the IPS, the Irish Prison Service, maintains the highest standards in governance and accountability. Accountability and oversight have a different significance in the closed world of prisons, encompassing much more than the prevention of human rights violations behind closed doors. They involve ensuring the prison system meets its own mission to provide safe and secure custody, dignity of care and rehabilitation to prisoners, and that it does everything it can to minimise the harmful effects of imprisonment on people so held. We welcome the long overdue publication of the general scheme, but it must be prioritised and accompanied by a firm commitment to adequate investment in the proposed governance and audit structures of the IPS, or there is an inherent risk that the new body will become a firefighting operation. The statutory appointment of the Director General as the accounting officer for the IPS at Head 34 is welcome. However, we would ask the committee to consider whether the proposed limitations on expressing opinions to Oireachtas committees other than the Public Accounts Committee is appropriate or necessary. While welcome that the Heads of Bill sets out the IPS board composition and membership, we would call into question the appointment by the Minister for Justice and would instead recommend that the legislation is crystal clear that appointments in whole or in part are to be made pursuant to a public competition managed by the Public Appointments Service. IPRT is concerned that the statutory power of the Minister, as set out in Head 52, to redact in part or in full the publication of the IPS annual report seems particularly stringent. IPRT suggests that the committee consider the need for such a statutory provision, particularly given the importance of protecting the independence of the IPS, and that the same does not apply to other statutory bodies. Recently, the Office of the Inspector of Prisons has increased its activity and output. This is welcome, but creating an effective and accountable system requires not only robust independent oversight, but also the shaping of a prison culture that respects complaints, acts swiftly to address any wrongdoings, and harnesses data and information to drive progress. Accountability is not a singular entity, one office, or one practice. Finally, the notable omission around prison culture and its importance cannot be overstated. It encompasses working relationships between staff and management and between staff and prisoners. Poor standards or poor service provision or treatment in day-to-day life can create a pervasive culture whereby people in prison tolerate poor conditions rather than challenge them to realise their rights. This is particularly relevant considering the ongoing review of the 2007 prison rules by the Department of Justice, as there is currently no adequate complaint system that offers an effective remedy for people in prison. We hope the review will be completed shortly. A robust and effective complaints system must have conditions in place which support it, including the promotion of a positive culture so that staff and prisoners can have confidence in the system to support better management overall. Our submission goes into more detail on a number of key heads of the general scheme, and myself and my colleague Helen Kehoe will be happy to answer any questions on them.
Great. Thank you very much, Ms Brady. And now I'll ask Mr Dalton on behalf of the Prison Officers Association.
Here, members of the Oireachtas Committee, on behalf of the POA, I'd like to thank you for the opportunity to address this committee on the General Scheme of the Irish Prison Service Bill 2023. My name is Carol Dalton, I'm the General Secretary, and I'm accompanied by my colleague Mr Gabriel Keaveney, the Deputy General Secretary. Due to the nature and composition of the bill, we obtained detailed legal advice on its contents, and our submission is based primarily on those advices. As outlined in our original cover note, our submission was presented subject to us seeking a meeting with the Department of Justice to clarify a number of issues, including the matter of the status of our members as civil servants and the impact of the general scheme of the Irish Prison Service Bill on their status. A meeting has yet to be confirmed, but we're in agreement to meet on that matter. We respectfully request that the committee allow us to submit any additional issues should the needs arise following that engagement. In our submission, we raised a number of concerns relevant to the assurances regarding our members' civil service status going forward. The IPS have outlined via Justice that the scheme has no effect on the civil service status or terms and conditions of staff, other than that they will become servants of the government rather than officers of the Minister. The main issues is the impact of becoming civil servants of the government rather than civil servants of the Minister. Clarity is required as to whether this change can impact on a range of existing collective agreements for our members and on the methodology for reaching such agreements going forward. Delegation of functions to the Director General, including the power to dismiss. Under this section, there are two main issues arising. In the first instance, the Bill gives the Director General wide-ranging powers in relation to the appointment of staff under the Bill and fixing the terms and conditions of employment of such staff, their grades and the numbers of staff in each grade. This is a significant move away from the process in place at present and presents grave concerns for our membership. During the financial emergency, the parties entered an agreement which resulted in significant staff reductions and the introduction of massive workplace reform. Part of this process was to examine staff to management ratios. In recent times, the IPS, in their opinion, have disproportionately increased management grades to frontline officers' grades. In particular, there has been a 35% increase in HQ staff. Secondly, in the wider civil service, the power to dismiss rests with the Secretary General of the relevant department. Currently, there is opposition from the staff side to any proposal to further dilute this power. Therefore, we require clarification as to specific functions that the Director General can delegate to subordinate members of staff, and will the Director General have the ability to delegate the power to suspend dismissed staff. Other matters that may impact on our members is, again, the main issue for our members is clarity regarding their current status versus the new status. For example, what will the impact for our members in placing the Code of Ethics on a statutory basis? The Prison Service currently has a Code of Ethics for staff, however, this provision will put it on a statutory basis, and what will that mean for our members? Thank you.
Thank you very much, Mr Dalton. Thank you for being so brief. Senator Rowan, I'm going to call on you first.
Thank you, Chair, and thanks for your contributions. I have a few questions under a number of different headings. I suppose a lot of them seem to be probably for Justice is just here in observation, are they? Or to
yes,
contribute?
I'm sorry.
Yeah.
I presume you guys don't want to say anything at this stage, but you're welcome to come in at the end if you have any questions or observations. Should have said that. Yeah. Sure.
Okay. So then the IPRT, and I've maybe one for the PWO. So the first one is in relation to Head 7, and I'd imagine this is at the IPRT, I suppose, and for the department to take note of is that I think it's Head 7 1E. In relation to education and training, I suppose there's a sentence in there that says if the sentence permits. And I just think that in terms of rehabilitation and access to education, that's quite a problematic sentence, because it means then there's a scenario put forward where we can say that the sentence didn't permit access to education or a particular course. Now that could be because they expect them to transfer, or they say they expect them to get out at a certain time, but that shouldn't actually be in there, and I suppose all accommodation should be made to be able to access education. In relation to Head 10, and actually the union might have comment on this in relation to staff at the service. One of my questions is in relation to mobility, I suppose, the importance of staff being able to actually move around in terms of having that status of a civil servant. But my concern with that is, and I'm wondering if it's a concern of yours when we look at independence, is it actually says a civil servant of the government. Which I think is problematic. I mean, when you look at other legislation, I think maybe the parole board, the inspector of prisons and stuff, it's actually of the state, and it shouldn't maybe be of the government to actually give it that real independence that it is supposed to exist in terms of separating some of those powers. I'm wondering in Head 12, there's no mention to kind of the Director General's role maybe in research and stuff. I think that maybe it would be beneficial to have something in there in research and development in terms of the Director General. Head 22, functions of the board, actually doesn't mention any sort of governance oversight or finance management oversight, and I'm wondering, should there be something in there in terms of, so that actual board actually has some power and oversight in relation to governance. Now, it does mention governance later on when it comes to an audit committee, but it doesn't actually have it in the functions of the board. In relationship to membership of the board, I'm just wondering about the makeup of that board. It obviously says in the heads that if somebody gains a conviction while on the board, they will no longer be able to serve on the board. But it doesn't actually say anything about people with previous convictions being able to serve on the board. And obviously we know there's issue, you know, with the charities regulators legislation and stuff. And it just kind of seems that maybe this could be an opportunity for us to actually ensure that people with lived experience could actually function on the board. So maybe if some comment on that. In relation to Head 34, I think is actually quite concerning, the accountability of the Director General. It basically says that the Director General can't really form or give any sort of opinion or criticism on the Minister or the government. So really it's like this illusion of giving independence, but actually really restricting that independence and the ability of the Director General to be able to actually, like obviously within the prison system, you know, you need to be able to challenge policy. Like if you look at mandatory sentencing or anything else that may come up in terms of policy, you would imagine that the Director General and I suppose the union members and everybody else would have a very particular view on that, that sometimes may need to be demonstrated to government or particular ministers of the day that may be taking a different policy that doesn't actually serve either the prison population or its staff or anything like that. So that, I'm just wondering if there was any comment in relation to that. I leave it at that for now because there's a few questions there.
Okay. Does anybody in particular want to take that up first? Yeah.
Oh, one more, sorry, in terms of transfers. It doesn't, I don't think it says if the Director General actually will take responsibility for transfers to open centres and stuff, so is there still power line with the Minister in that regard?
Okay, Ms Brady first.
My colleague will come in if there's anything else to add. I suppose on the education piece, Senator Rowan, yeah, I think what we often hear is that people on short-term sentences can't really engage with education, but when we look at the prison population and how many of them are in for 12 months or less, that's quite concerning because we do need to find a way to ensure that they are engaged. Personally, I think if they were serving their sentence in the community, that would probably be a better use of resources and we wouldn't have to really worry about that piece. But that, I suppose, isn't being dealt with necessarily here in this piece of legislation. In terms of Head 12 and the research and development piece, the Director General having that within the functions, I think that is something that could be looked at. In terms of the board, the finances and governance piece, yes, our understanding of it is that it looks like it's more of an advisory board, but certainly any board, if you want to set up something on an independent footing, then, you know, it's about the transparency, the accountability. So there should be governance and finance oversight put in place. And we would also, in our submission, we talked about the expertise of that board. So we would hope somebody with human rights experience or expertise would be on that board. And the piece around the lived experience, it is tricky, but there is a way to get around it for the charities legislation. You can go to the High Court and get a dispensation. So it is something that should certainly be looked at. Maybe even if somebody cannot serve on the board, that there should be an advisory committee of some sort where people with lived experience are feeding in. I think there has to be something there. Yeah.
I want to let the prison officers in, and if you need to come back in, I'll let you in.
Perfect.
A couple of points on the staff of the service and mobility. That is a concern we'll be raising, and as we said, we look for a meeting with Justice Force to clarify the full meaning of the terms that are within the document. As in, so we have civil service mobility. We represent civil service grades as well as prison officers, and there is civil service mobility currently, and that is one of the themes for our whole document will be, what does this change of status mean for our members, and that will be one of the things. On the membership of the board, my colleague could just talk about the last time there was an interim board. There was a place for us on it, and we're not excluded, but we aren't included on it, and that may be a concern.
There's no workers' rep.
That'll be that issue.
Yeah, that's a long time ago. In the history books, just a bit of research on it, the Interim Prisons Authority, there was one of our colleagues, previous colleagues on that. We're not saying it's a hard or fast one, but it's the only thing we can draw a parallel from.
Yeah.
Okay, sorry. Happy enough then?
The opinion and criticism and the Director General's ability to be able to actually criticise, or not necessarily criticise, but have an alternative opinion, I suppose.
I won't open it up at this stage, but I'm going to go to Deputy Pringle and then we can come back possibly later on.
All right, thanks, Chair. My questions are along the same line as Senator Rowan's anyway, so the answers will be fairly similar. I mean, in relation to the looking at the legislation and all parts of it, the Department of Justice seems to be retaining hold of the legislation. I think that's a big problem, and I think it's not surprising, really, in terms of how the Department of Justice does its job and sees its role, I believe. And I think it's going to be a fatal flaw in the actual legislation as well, too, because this is going to be seen and presented as reform has been carried out and it's done and dusted now for the next 20, 30 years or whatever. And it actually isn't any real reform, I believe, because the Minister is retaining ownership of some of the very significant and very important parts of the legislation that would really, I think, would make up a statutory body and a new independent body as well. So I suppose really there's not too many questions on that, but if you could answer in relation to Senator Rowan's questions, but I think that's the same thing that I see as well as like the Director General in Head 34 that is very restricted in what they can actually do in relation to that there. And then when you go look through, then you see in Part 4, the Board of Service, it's appointed by the Minister for Justice, not an independent body. Again, it's another problem. Then Head 52, the Minister for Justice can redact or not. You know, so it's Department of Justice retaining ownership of all the important parts of this legislation, and I think that's a real problem. And maybe if you could just expand a wee bit more on that in your answers. And then just in relation to the prison staff and the code of conduct of prison staff. It's not a statutory code of conduct at the moment, but if it is statutory, how would you see that impacting? What's the difference? If the code of conduct is there at the moment, is there, but I presume it's voluntary or whatever, or that, you know, what is the difference going to be in relation to that in the future? And I do think that in relation to the role of the staff as well in the future, that is significant, and I would like to hear back from you in relation to what you see, what the outcome are from talking to the Department of Justice in relation to that, because I think that would have an impact in terms of your terms and conditions anyway, definitely in the future. I noted just you said that if you wanted to set up the system on an independent footing, I don't think you would go down this road, but just hear what you want to say. Thanks.
Okay. Does anybody want to come in particular on that? Yeah. Let's go.
definitely we would have concerns around Head 34 in particular, around the DG being so restricted on what they can say before Oireachtas committees. Certainly it's not something that we could see in evidence with other kind of similar independent public bodies like the Human Rights and Equality Commission or the Ombudsman for Children. They are limited in what they can say before the Public Accounts Committee, but not Oireachtas committees generally. So it's not entirely clear to us why they would be so limited in their comments on policy, and it's something that we would urge the committee to look at again. In particular, the notes for the scheme as well talk about this being modelled on Section 72 of the Policing, Security and Community Safety Bill 2023, but we would have concerns there, and that is an untested piece of legislation. It's still in draft, hasn't been enacted, so it's a little bit nebulous as to why that's being relied on so heavily in this particular circumstance.
Yeah, a similar provision was in the Inspection of Place of Detention Bill, and we would have raised similar concerns there as well about the limiting of, you know, you have a Director General who will know the system inside out, and their concerns or opinions should be very valid and should be taken into account. So we would question why that isn't there. And the transfers to open prison, yes, that should be something that's considered as well. I know Senator Ryan brought that up.
Okay. Sorry,
just even in terms of, and I know our friends here in the POA will talk about this more broadly, about the code of conduct and the role of staff, but in terms of the role of staff, we would see that there is that broader issue around the culture within the prison service as well, and that certainly from our point of view there is a very obvious role there for a culture committee within this new body, so that the staff can feed into that as well. So it's not just about, it's about everyone in prison, not just the prisoners, but the staff as well, and how they feed into that system more broadly.
Okay, thank you. To you guys.
Yeah, just in relation to the role of the Department of Justice, like our view would be that we either go independent, like fully independent of them, or we don't. You know, there's mentioned parts that we're not legislators, but there's mentions in relation to the Secretary General. The Minister's mentioned an awful lot in it, and it would be we either go all out or nothing at all. In relation to the Code of Conduct, we have no issue whatsoever with the Code of Conduct, other than it's explained to our members in relation to what it means for them, what they're expected to do, and what they're obliged to do in relation to the terms of the Code of Conduct. And in relation to, say, culture committees, anything like that, of course, no issue. But there's a lot of committees that talk about a lot of things. We want, you know, if it's going to be there, that actually deals with some of the issues that are present or that are perceived to be there.
Okay, thanks. Ms. Brady, you want to come in briefly?
Pringle brought up the redaction of annual reports. That's also obviously a big concern for us, because at the moment the Inspector of Prisons reports are, you know, they have to go to the Minister first, and the Minister can choose not to publish them, and we are in a situation where that's happening at the moment, so we do think that should be fully independent.
Okay, thanks very much. So, did you want to come in?
Just 1 second, yeah.
Very briefly.
Just on the Code of Conduct and the culture, we have a history in the Prison Officers Association of driving cultural change, and we have no fear of that, and we embrace it. In fact, we were the ones that brought in the incentivised regime for prisoners and all these things. These policies we believe are positive, and we're a driving force behind that. Just wanted to make that statement.
Okay, great. Thanks, Mr. Dalton. I'm going to go to Deputy Farrell now.
Thanks very much, Chairman. Good afternoon to our witnesses, and thanks very much for coming before us today. Apologies, I'm not able to make it down to the committee room just at the minute. I'm on 2 committees at the moment. I just had a quick couple of quick questions in relation to Head 15 and Head 24, so temp release and then board appointments, the general independence and oversight. And I just wanted to give an opportunity to our witnesses to make some comments in addition to that they've already made. Do you feel that Head 15 in particular in relation to temporary release is robust and sufficient? And then in relation to Head 24, quite a lot has been mentioned in relation to board appointments, and I know the general scheme rather says that it's envisaged that the appointments will be made in accordance with the general application open process for the appointments of persons to state boards. Do you feel that that is sufficient? And then finally, in relation to oversight, which I know you've already touched upon, but you might make a comment on any further observations that you might have in relation to that oversight function, and I mean parliamentary oversight. Thank you.
Okay, thanks, Deputy Farrell. Does anybody want to come in on that first? Yeah, Ms. Kehoe.
It's just in relation to Head 15 and temporary release. We're glad to see it in the general scheme, but as we've noticed in our submissions that we would have concerns around its wording, because at the moment it's a little bit, as matters stand in legislation, it's a little confusing, and we know from people that ring us on the ground that it is a very confusing process in terms of whether it's the Minister or the IPS that has ultimate responsibility for how temporary release functions, and that they kind of tend to be bounced between the pillar and post. We would be concerned that as Head 15 stands, that's not actually going to clarify anything, but might even possibly confuse things further, because you have a situation where the Minister may, in writing, delegate that responsibility, but he may also decide to rescind such a delegation. So we'd urge the committee to think about maybe this is something that could actually be clarified at this point in time with this scheme as to who exactly has ultimate responsibility for the functioning of temporary release and how that might be improved upon in future, rather than leaving it in this kind of a grey area for people on the ground.
Okay. Does the POA want to? Oh, sorry, Ms. Brady. Or
Go first.
On the temporary releases, the conflict affects prison officers on a daily basis, and it links back to Senator Rowan's point on services. There has to be a flow through the prison, and at any given point it should be really clear how someone achieves temporary release. It should be really clear, and it maybe opens the door for a political decision to stop TRs for temporary releases. For instance, when there's overcrowding, who makes the decision? Will it be a minister that says this timing of this doesn't suit for people to be out in the street, or will it be the opposite way, and other times the Director General has the control over that? So it ties in with the whole ethos that the Prison Officers Association involved in, having a clear plan for prisoners from the day they come into a prison to the day they release, and that mightn't sit just perfectly with that.
okay, Ms. Brady, do you want to come back in?
Just on the appointment of the board, I suppose it does say in the notes that it's envisaged that it will be a public appointments process, but that's not what the draft legislation says at the moment. We find that more and more where the notes are have the intention set out in them, but the legislation doesn't. And in fairness, the judge isn't going to go back and look at the notes to the general scheme when interpreting the legislation at a later date. So I think that's something that needs to be crystal clear in the actual draft legislation and act as enacted.
Absolutely agree with you there.
Are you happy enough, Deputy Farrell?
Yeah, no, happy enough. It was just a general view of those two heads that I had some concerns with. Thank you.
Great, thank you very much, Deputy Daly.
Yeah, thank you, and you're all very welcome. I was going to ask about temporary release also. Just reading what was said here again by the IPRT, seeking clarification. But in the prison officers, prisoners tend to be very reliant on the staff to process these applications also, and from my understanding is that the Garda would have, the local guards of the person applying would be consulted as well, maybe by the IPS. Isn't that the case? Or maybe I'm wrong there, but what's the prison officer's view about like having an independent body, separate to the prison officers, because as I said, my understanding is that they help a lot with the processing of forms and that by prisoners who may have, a lot of them may have literacy issues. And just in relation to it was mentioned by the IPRT, but I'm asking the Prison Officers Association about the education and training. We hear a lot, and over the last year or two, we've had a number of briefings in relation to penal reform and the numbers of prisoners, for example. I think we heard on a previous hearings that 4% of remand prisoners were in prison for more than 1 year in 2019, and that was up to 12% in 2021, and it has declined slightly to last year. So there's a lot of prisoners, or more certainly than there used to be, are on remand, and what opportunities are there, if any. But is it the case that where there are pressures on staff, that what we've been hearing is that the schools and the shop are the first ones to be cut for prison officers, or for prisoners? Is that the case? And
in a situation, what I'd be slightly worried about is in the conditional element, they mention having full regard to the resources that are available. And in a situation where, from what I understand, in the Midlands prison, there was 2 counsellors which were provided by Merchants Quay, I think it was. And that's the limitations on resources that are there. Set as, never mind, psychologists and everything else. Would you have concerns about in what's there in inverted commas about the full regard to the resources that are available? Would you have any comment to make on that? Because we just hear an awful lot from particularly from prisoners that the rehabilitation is very limited in going through the system.
Okay, I'll just come in on the first part, which is the temporary releases, and all we would say on that is there should be a clear structure in place in how a prisoner obtains temporary release. There should be a connection between that and their behavioural pattern, and also we see at times it's easier to get temporary release out of, say, prison X or prison Y. There's no consistency, or certainly not enough consistency between it, and certainly the open centres should be utilised, and they should be the driving force that ultimately a lot of people would end up there. And I do believe there is some contact in some cases with An Garda Síochána in respect of whether prisoners are released or not, certainly more high profile situations.
I'll come in on the education training and the workshops being closed. Firstly, we have what's called a regime management plan, which we've engaged with the Irish Prison Service. It's for safe systems of work for staff when there is inevitable shortage comings in staffing areas. The key, or the priority, one of the first priorities is that structured activity should be protected. So in other words, you maintain the structured activity first, and you try and get as many people. And the simple way of explaining that is, if someone's going to school every day and we have staff shortages, well, we change the programme and they might only get a half a day, but we continue to make sure they have structured activities. From our perspective, prisoners that are engaged in structured activities are far less likely to injure one another or injure staff. So for us, it's enshrined in one of the recent national pay agreements. We enshrined the regime management plan for the safe systems of work. But again, you have to go into that and look at the priorities, and the first priority is structured activity, the schools, the workshops. When prison officers take prisoners from them areas into workshops, there's less trouble in the prison. It's a happier environment. The prisoners are more content, and it ties in again with the services lead into the behaviour, the behavioural pattern, the incentive regime leads into the ability to get TR and to have a constructive time in prison, leading to release at a better time.
Is there much disruption to the structured activities?
It depends on the prison. Some prisons are very good at the regime management plan, and they should be held as the model to be followed by the rest of the prisons.
Which ones are the better prisons?
Midlands prison at the minute. Midlands prison there at the end of the term had 46 prison staff that would have been in workshops. Staff shortage is fairly heavy. They managed to get 39 of these officers into the workshops.
Could you say which prison is falling down?
We won't be too critical, but what we can say is we have raised with the prison service before where they would actually close a school where there's 18 or 19 teachers and they would divert the prisoners to the exercise yard. We think that's a complete, no, to be quite honest with you.
In other prisons, is it?
That can happen in prison.
It's some locations, yes. And we've highlighted that several times. We just don't think that's, the yard is the worst place. There's intimidation, there's bullying, there's drugs coming in over the wall, etc., etc.
And just one final question arising out of what you said. You mentioned, Mr. Keaveney, the open prisons and moving prisoners to open prisons. And
yes.
some I think, do they have to serve half the prison term a lot of the time before they would get sent to an open prison? And do you think that that's something that could be changed, that maybe prisoners could be moved at a very, very early stage to an open prison, or what's your opinion on that?
They have a policy in place, the Irish Prison Service, in relation to how people are moved to open centres, but it should, in actual fact, be more, based on, say, the previous history, the sentence that they're in for, etc., etc. We've had difficulty getting prisoners cleared for open centres, and it only happens when the overcrowding came back that they started to send people. Our strong belief is that there's only about 10%, that's the numbers roughly that the open centres equate to, and there should be a waiting list for the 2 open centres for certain. And one of the other things we asked, or we raised with the prison service some time ago, was that the Grove area in Castlereagh be utilised for maybe prisoners that are not deemed suitable for the actual open centres themselves. It's more similar scenario, and they've done that, and there is sex offenders being moved there now to that area.
Despite the time having lapsed, I know Ms Brady wanted to come back in, so I'll just let her in briefly.
Yeah, so just on the shutting down of schools or any of that, we do get calls around that, but our understanding as well is there is a huge amount of pressure on the IPS in terms of court escorts, and sometimes resources have to be diverted for that. Now, there was 100 extra officers were allocated in last year's budget for education, but I don't think that was necessarily ring fence. I think some of those have been put in place, but not all of them. And just on the resources piece, we would be very concerned that it talks about available resources. Ultimately, the IPS has a duty of care for the people in its custody, so it shouldn't be limited by resources in terms of how they provide for those people. You know, we have a situation at the moment where we have overcrowding, people sleeping on mattresses. That is not conducive to anybody's rehabilitation or care. So we need to address that, I think, as well, and ensure that there is investment in any new structure that's gone in, and the IPS can ask for what it needs, and that it is granted the sufficient resources.
Okay, thanks very much. I'm going to go to Deputy Costello.
Thank you very much, Chair. Many of the stuff I wanted to say has been raised already, and I'm conscious that we have time ticking against us. One of the things that I'm conscious of, it's been raised, just to say for the record and for our report, I think a couple of grey areas that need clarification have been highlighted in relation to temporary release, in relation to the delegated powers between the Director General and the Secretary General. So I think those things need to be tightened up. I would also think that it's very important that we put into our report the issue around the publishing of reports, the silencing of people who may come before committees. I'm conscious there are 3 reports in relation to the Docus prison that have not seen the light of day in quite some time, and I think that transparency and openness is absolutely essential, and I think anything that limits that is problematic. One of the things I wanted to pick up on was the code of conduct, because the code of conduct provides for consultation with a variety of groups, IREC and others, with representative groups like yourselves and the Prison Officers Association, but it doesn't explicitly say that there needs to be any consultation with prisoners themselves. As much as prison officers are living under a code of conduct or a code of ethics, prisoners will be living under a regime that creates. And in the same way, I've always argued that there should be public consultation in relation to, for example, Garda regulations or Garda codes. I fully believe that we should find a way of, and it shouldn't be that hard, of conducting some sort of consultation with prisoners, and that needs to be explicitly named in the bill. The bill provides that conduct can be done with anyone the Minister feels is relevant, but I think that has the potential to end up being nobody. And if we want to recognise that prisoners are living under this code of ethics too, then they need to be named explicitly at that point. I don't really have any questions, which might move things along, but if anyone wants to respond to that very briefly, I'm sure the Chair would add, feel free.
Does anybody want to? Yeah, sorry, Mr.
Powers, that's an issue for ourselves in it. We just want to explain to us fully what it means for our members, what it means for the powers of the Director General as opposed to what is currently the Secretary General. That's one of the issues. In relation to who's been consulted on the Code of Conduct, we have no issue whatsoever. We've sat in rooms with prisoners in relation to various issues, both us here and across the water. So the more people that's consulted, the better, once the right Code of Conduct comes into place.
Thanks very much, Ms. Brady.
Yeah, we'd agree, and it should be meaningful consultation, not just a tick box exercise. So you need to find a way to actually consult meaningfully with prisoners, because what we find is, we consult with prisoners, but people who are in long-term sentences have very different issues to those who are in short-term sentences. So it needs to be fully reflective of the prison population as well, I would say.
Great, thank you very much. Okay, you're happy enough, Deputy Costello?
Yep.
And Deputy Smith. So that completes round 1. Does anybody want to come in with anything further? Senator Ruan, 3 minutes.
I just have 2 questions really.
The first one is in relation to actually, it says, I suppose, it says the minister will lay out, I can't remember what heading it is now, that the minister will lay out the priorities for the year. I suppose it's back to that separation thing. I'm just wondering, like, if there is independence, should the Director General and its board not be the ones in a position to lay out the priorities? Obviously in consultation or in collaboration, but it just kind of, it just seems counterintuitive, I suppose, to what the intention of the bill is. And then the other one is, I don't see anything in the heads, I suppose, in relation to the VLO, the Victim Liaison Officer, and whether there should be a legal basis maybe for their involvement as well with the IPS, and whether that could potentially be done through this legislation or through, I suppose, looking at the makeup of the board. I suppose I've obviously a research in, an interest in restorative justice practices and stuff, and I just think having maybe the VLO having much more involvement legally, like on a legal basis, and I just wonder maybe what the thoughts are on that.
Yeah, I'll come in and Helen, if anything else. Yeah, I suppose in terms of the Minister laying down priorities for the year, yes, it should be the Director General. You know, I suppose it'd be somebody in my position. You know, I with my team led on the priorities for the year, and we have our strategic objectives, so I imagine the IPS will have its own strategic plan that it works to, so that is something. Of course they should consult maybe with the Minister to see what the pressing issues are, but they should have the ultimate say. And in terms of the Victim Liaison Officer, yeah, I'd agree that there probably is a role there for them as well. So this could be a really good opportunity to try and thread that in and ensure that is included, because I suppose IPRT would be very much in favour of restorative practices right across the prison service as a whole. Helen, do you have anything?
Okay, and does the POA want to come in?
On the Minister laying out priorities, the strategic plan comes out and it normally has a number of pillars of which we're going to operate to. From our perspective, it takes a number of years to have change in a prison, so it can be, if a minister is going to interfere with that. Currently the strategic plan is there's the 5 pillars, and we work towards that from a staffing perspective. Whatever direction we're given, we'll lead the staff to go in that direction. In terms of the Victim Liaison Officer and restorative justice, we've very limited experience of restorative justice, but any time we've engaged on it, it's been positive enough, and we'd have no issue around that kind of thing.
Thank you.
Okay, happy enough? Sorry, yeah, you're okay? Does anybody want to come in then else on round 2? Okay, that completes the question then. So, in the first instance, is the Department of Justice happy enough? Is there anything you want to add?
Thank you, Chair. We'd like to thank the committee for the opportunity to observe this pre-legislative scrutiny, and we'd like to thank the witnesses and the committee members for their interest in the scheme and the thoughtful points they've made. We've listened carefully to everything and we'll reflect on it. And we look forward to receiving the committee's report in due course, and we'll give it the fullest consideration. We're also happy to respond to the committee in writing should it need to clarify any matter. If there's one thing, briefly, if I might be allowed just to clarify, there were a number of comments on the need for the provisions to reinforce the independence of the body and its CEO, including matters such as providing the CEO with an ability to comment on government policy. Just for the avoidance of doubt, the purpose of the bill is to provide a statutory basis for, essentially to provide a statutory basis for the IPS's functions as a service delivery body that, as it stands, delivers a government service on behalf of and in the name of the Minister. The essential purpose of the bill is not to alter in any fundamental way that role or the role of the Director General as the person with overall day-to-day responsibility for delivering those services. Rather, the purpose of the bill is to create a full statutory basis for the functions and responsibilities of the IPS, and to put in place a best practice statutory framework for its governance and its accountability, including its accountability to the Minister as the government representative who will continue to be politically accountable for the performance of the prison system. So just wanted to say that.
Thanks very much, and thanks to Mr. Farrell and Mr. Tehan for being present as well. That concludes our questions and answer session. I'm going to propose that we publish all the opening statements on the committee's website. Is that agreed? Okay. And on behalf of the committee, I want to thank you all very much for coming. I think it's very valuable input, and everybody has the benefit of your particular perspectives and understandings as well. Before we go on to the next matter, I'm going to suspend the committee, and we're going to go into private business for 10 minutes, if that's okay. So I'm going to ask everybody to step out except the committee members, if that's okay. Thanks, everyone.